Okay, great. Welcome, everyone. I'd like to welcome you to this NPDA event we're having tonight. I am Joni Williams. I work with Albers Communications, and I am the PR firm that does work for the NPDA. We help put on these events, and we want to thank you again for taking time out of your evening to attend this event. This event is a continuation of our successful series of webinar programs that we've designed to help inform and educate family caregivers. It's brought to you by the National Private Duty Association, a trade association of home care agencies who provide quality in-home care services. As many of you probably know and have experienced, an aging parent or loved one, the best place for them for the long run is aging at home. They prefer that much more than being in a facility somewhere. So these programs are designed basically to provide information to family caregivers to help them provide the best care for their loved one while they are at home. Again, as I mentioned before we get started, you can chat in questions down at the bottom, and we will address those at the very end of the event. Just to give you an overview of what we're going to be talking about tonight, the topic is addressing legal issues that impact seniors. We'll be covering a wide range of issues. The live and interactive program will provide advice on elder law matters, including pinpointing when you need to address legal issues, what the implications are, and how to ensure that you and your family are protected. Caring for an aging parent brings many challenges, and it's vital that a family know what legal issues they need to address and the appropriate timing involved. Being knowledgeable of these issues is key to protecting your aging parent, providing the best care possible. The web conference topics today will include an overview of elder law issues, powers of attorney, informed consent and guardianship, advanced directives, wills and trusts, and many other issues. Our expert presenter today, we are very, very excited to have Joseph Monahan. He is basically an expert on social work issues as well as an attorney, so he's got a great combination background. He is a Master of Social Work. He has an ACSW, and like I said, he is an attorney. He is currently the legal counsel for the NPDA. He received his bachelor's and master's degree in social work from the University of Illinois in Champaign and his law degree from DePaul University College of Law. He is very involved with training and counseling for several legal and social issues groups. We'd like to welcome Joseph Monahan.
Thank you so much, and it's a pleasure to be here tonight. I'm thrilled to be a part of this program, and we have identified many issues that I cover in my elder law and mental health law classes that I teach at Loyola University College of Law. So we are going to try in the next 25 minutes to cover a whole host of things that I hope will provide some interesting information about all of the issues that confront you as you try to care for your parents and other elderly persons. My goal tonight is that you learn something that you can use. I hope that the information that I provide is practical and give you some ideas about how you can address some of these very, very difficult issues. The very first piece of advice that I have and comment is that I'm not going to provide any legal advice tonight. That would not be appropriate for me to do. My first advice, though, to you is to get competent legal counsel to address these very delicate and often complex issues. Do not rely on a real estate attorney that you know. Do not rely on a friend unless they are trained in this specific areas of the law. And when you get a referral for an attorney from a friend, just make certain that you feel comfortable with that lawyer so that you have confidence in the type of information that this lawyer is giving you. Today, there are so many people who are holding themselves out as elder law specialists, and you have to be very careful about getting an attorney who is able to very much help you. So what's so unique about elder law? Well, there are so many things that impact our people who are elderly. And then lawyers have to be trained to be able to address things like nursing home contracts, long-term care contracts, powers of attorney, and address issues which are so much more complicated today than they were 20 or 50 or 100 years ago. Today we have so many different types of family arrangements. blended families. People are living longer and often may have 1, 2, 3, 4 marriages and all of the complex issues that go about. Who makes these decisions? Who makes the informed consent decision when our elderly parent or grandparent or loved one is not able to make the decision? Should we go ahead and get guardianship? What is guardianship anyway? And what about advance directives? We hear about advance directives. Should my elderly person that I'm caring for have an advance directive? What about a will? What about trust? And what exactly is a special needs trust? Today, because people are living longer, we are seeing an outbreak of elder abuse. What do we do when we see elder abuse? How can we report it? What is elder abuse? What is elder neglect? And are there any resources out there for people who are working in the field? And the answer to these questions is absolutely. Let's start first talking about some of the legal issues that we have special for persons who are elderly that you might be working with. Let's think about the decision-making that people have when they're faced with health care and financial issues. What about the legal issues when people are moving out of their family homestead, perhaps going into a nursing home? What about these blended family issues? What happens legally when one spouse is in need of a nursing home care and another spouse is not? How do they afford it? Can the state take all of their money? How do we select medical and long-term care policies? Insurance companies are marketing strong long-term care policies. Which ones are good? What about the geographic challenges for children who are living on the East Coast or the West Coast and parents are in the Midwest? In other words, when parents are living out of state of their children, how do you select and manage appropriate health care to make certain that the health care providers that you are providing are not taking advantage of your loved ones? These are just some of the legal issues that we have to confront. Next issue is informed consent. What happens when mom or dad is no longer able to provide the consent for medical care? Who should do that? And if we are looking at substitute decision makers, what kind of substitute decision maker should we depend on? Should we use a formal guardianship, or are powers of attorney okay? Let's take a look at some of these issues. And the first thing I'd like to start off with is just the general notion of informed consent. Informed consent really is the bedrock principle of all medical care. It starts with the idea that the patient has autonomy, that the person who is seeking medical care really should be the person who is able to make their own decisions. And oftentimes we have people who have been making decisions for themselves for a whole long time, 80 years, 90 years, and now somebody wants to say to them they are not able to make their own decisions. How do we address that? Well, from a legal point of view, the law says that all people over the age of 18 are competent. They are competent to make their own decisions. And we know, working with people who have been diagnosed with Alzheimer's or other similar conditions, they may be over the age of 18, but they certainly are not competent to make their own decisions. And so I like to make the distinction between, even though a person is legally competent, they may not be clinically competent to make these decisions. I often ask my clients to look at 4 elements when deciding whether their person, their loved one, the person that they are taking professional responsibility, is able to make an informed consent decision. Number 1, does that person have the cognitive ability to make this decision? Do they really have that ability to understand and make the complicated decision that they have to make? Number 2, do they understand their choices that they have to make? Do they understand if a doctor is telling them they have this choice or this choice, have surgery or not have surgery? Do they understand that? Number 3, are they able to communicate their understanding of the proposed procedure or the proposed intervention? Are they able to communicate that in such a way that you, the person who is taking that informed consent, are they able to communicate it that they truly understand? And finally, the 4th element is this a voluntary decision that this person has made? Is it coerced? Is it forced? Is it something that the person really actually wants to do? If you have those 4 elements, you are on your way to determine whether this person is able to give informed consent for whatever the medical procedure is that's proposed. If a person is not capable of making and communicating responsible decisions for themselves, the legal action known as guardianship in many states or conservatorship in other states is something that should be considered. In Illinois, for example, a person who is in need of a guardianship is known as a disabled person. The court has power to appoint a guardian if the court specifically finds that the person is unable to make and communicate responsible decisions concerning the care of their person or their estate. The court uses a physician's report in order to make that determination of the person's need for guardianship. And in Illinois, as in many states, there are different types of guardianship that can be obtained. There's guardianship of the person, and there's guardianship of the estate. Obviously, the guardian of the person makes all the personal decisions, and the guardian of the estate makes all the financial decisions. One of the things that I get questions about all the time is can't be my mother's guardian or my father's guardian because I don't have enough money to be financially responsible for them. You do not become financially responsible for the person that you accept guardianship. You become responsible for managing their funds, but you do not become guarantor of their debt unless you voluntarily agree to do that. Who may act as guardian? Well, who may act as guardian is also going to be defined under your state law. In Illinois, for example, one has to be over the age of 18, not a convicted felon, and able to provide a suitable program for guardianship. It's funny. Recently, the Illinois legislature found it okay in some cases for even a convicted felon to be a guardian under certain circumstances. So when I say that you can no longer be a convicted felon, that's not exactly true in Illinois. You can be a convicted felon and still be guardian, depending on the type of felony that you have convicted or been convicted of. Guardianship is not for everyone, and I would urge you to very carefully consider whether guardianship is the correct thing for the person that you seek guardianship for. Because the effect of the appointment of a guardian is very severe on the person himself. In effect, a person who has a guardian, for all in most intents and most purposes, is a non-person in the eyes of the law. No longer are they able to make decisions for themselves if the court appoints a full guardian. They are not able to provide written and informed consent for medical care. They are not able to write checks. They are not able to use credit cards. They're not able to sign leases because for most effects, their signature is no longer valid. They seek the person who has a guardian to make those decisions for them. Now, there are different types of guardian. In Illinois, for example, we have a limited guardian. In some states, The person who is in charge of the finances is called a conservator. But you really have to understand the state law to determine what the effect the appointment of a guardian will be. And in Illinois, again, using it as an example, there are some areas where a guardian does not have the authority, even though they're the full plenary guardian, the full guardian of the person, for example. In Illinois, there are 4 areas where the guardian does not have the authority. They do not have the authority to admit them into a mental hospital or to make them take psychotropic medications against their will. Or the guardian cannot force a person to have electroconvulsive therapy, shock therapy, against their will. Or a guardian cannot force, in Illinois, a person to go to a nursing home against that person's will. So there can be advantages and disadvantages of guardianship, and you have to understand that before you seek the guardianship or recommend guardianship for any particular person. What are the advantages of guardianship? Well, certainly the advantages of guardianship are that it adds protection to people. They allow somebody else to make decisions when somebody can't make decisions for themselves. They're able to protect their assets, secure their assets, and make certain that their assets are going to be available for longer and not have the person financially exploited. The disadvantages of guardianship are that it's a public proceeding in court, that there has to be regular reporting to the court, usually on an annual basis. And so therefore, when thinking practically about whether you should recommend guardianship or obtain guardianship for a person, you have to think about what the effect will be, where you need your authority, and some of the advantages and disadvantages of guardianship, including the cost that it will be to go to court. Guardianship is a very, very, very powerful tool if it's used in the right way. Sometimes, however, if people do planning, guardianship is not going to be necessary if a person has a power of attorney. In 1990, Congress passed the Patient Self-Determination Act, and it provided that any time a person is admitted to a hospital anywhere in the country, they have to be asked, do they have an advance directive? And if they don't have an advance directive, such as a power of attorney, the hospital generally will have someone on their staff that will assist that person in obtaining a power of attorney. Like the guardianship, powers of attorney are broken down into powers of attorney for health care, where the agent under the power of attorney makes decisions about health care, and usually there will be a power of attorney for property, where an agent can make decisions about a person's property, pay their bills, make deposits, collect, sell houses, however much authority the principal gives to the agent. A couple of quick things about powers of attorney. Number one, powers of attorney are based on agency law, and it is very, very long-standing. Agency law is very, very long-standing, and there are 2 people usually involved in powers of attorney. First, it's the principal, and second, it's the agent. So I, as the principal, could appoint you to be my agent and give you authority to do something on my behalf. For example, if you were a real estate agent, I could give you as the principal, I am the principal, you would be my agent to sell my house or to buy a house. I would give you authority under our agency agreement to act for me in my stead as it relates to my real estate transaction. Similarly, if I wrote a book, I would hire a book agent. Or if I made a movie, I would hire a movie agent. I, the principal, would give the agent the authority that I wanted to give them. Two principles of agency law are very important to understand. First, the principal must be competent, and second, it's always a voluntary agreement. So, if I have somebody, if my mother or my grandmother is demented and doesn't know what planet she is on, she would not be a candidate for an agency agreement, a power of attorney for health care, because she would not have the ability to appoint an agent because she would not understand that. Similarly, if I appoint my wife and I say, if I become ill, I would like you to make decisions for me. However, if I, for some reason in the future, no longer want my wife to serve as my agent because I believe, because of some mental illness or some other reason, that she is no longer the wonderful person I love as my wife, but rather she is a broom rider or she is the devil, I can fire her at will at any point in time. I do not have to be competent. Why? Because agency law says that it's a voluntary act. And even if I don't care for her at the present time, and even though I might not be in my right mind, I can terminate that relationship. Now that's unique to Illinois law. I believe that a number of states will permit that. And however, in Illinois, they've made it different for powers of attorney of property. You do have to be competent to terminate that. Let's talk for a moment about mental health treatment preference declarations. These are super powers of attorney and started in Minnesota many years ago. Illinois took Minnesota's lead, as well as about, I think the last time I checked, about 22 other states have some type of mental health power of attorney that's slightly different than your regular power of attorney. The reason I mention it is for many of our people are mental health challenged or have some mental health diagnosis, and during the time that they are competent, when they are taking their medication, we seek to have them sign one of these mental health treatment declarations that provide that they can be medicated against their will, they can be admitted to a hospital, or they can use electroconvulsive therapy. These are very, very powerful documents for people who suffer from mental illness. So I would check your state to see if that might be an option for you. What's key to those mental health treatments is the notion that they cannot be terminated without a person's permission, and they cannot be terminated when the person is suffering from the mental illness. We have a few other things that I wanted to talk about in our remaining 4 or 5 minutes, and just the importance of having a will and trust. The purpose of a will, of course, is to decide what you want done with your property when you're no longer around. A trust is a unique estate planning device that will avoid probate and allow you to be a little more creative in the way you dispose of your property. Some people say, do I need a trust and a will? I would recommend for most people that they have both, a trust and a will. And certainly you want to make certain that you speak with someone who is aware to implement the trust to make sure that it's funded so that you have an appropriate trust for yourself and an appropriate will. We could spend a seminar just talking about wills and trusts, but I wanted to highlight the notion of because we're working with people with disabilities, there's a thing called a special needs trust, and we could provide an overview of a self-settled and a third-party special needs trust. When you go talk to your estate planning professional, make certain if you have a person in your life who has special needs, whether it be mental illness or they are elderly or they have some special needs where they may be eligible for public benefits, you want to make certain that you talk to a professional who will be able to tell you about the goals of a special needs trust, when to use it, and certainly sometimes in a pool. Because the population is getting older, unfortunately, we are seeing a rise in elder abuse. And elder abuse is going to be defined in state law, and there's going to be often a distinction between abuse and neglect, and what some people will refer to as self-neglect. Most states now will have a reporting mechanism that mirrors kind of the child abuse reporting mechanisms to protect elders and to ensure that elders, to the extent that we can, are protected from all of these scam artists and things like that. There's lots of potential litigation out there because of all the elder abuse and neglect that's going on. There are a number of resources, obviously, throughout the country, and we've mentioned a few here in our last slide, that we would encourage you to learn more about this. AARP, the Alzheimer's Association, the National Academy of Elder Law Attorneys, the Family Caregiver Alliance, and the National Family Caregivers Association are just some of the few of the many, many resources on both the national level, and then it's incumbent upon you to look in your own state to see what kind of resources you can find for the place that you want to do. I understand there's some questions out there, and I'm happy to spend a few more minutes. Jody, we have a few minutes, right?
Yeah, we have
questions.
Yeah, we have some questions, and also for any of you that didn't hear this initially, on the chat function, you're welcome to chat in some questions, and we can address those after we've gone through the first couple that we have. The first one we have, Joseph, is who has more authority, a guardian or an agent with a power of attorney? So what's the differentiation there?
Excellent question, Jody, and I will tell you that it's going to depend on simply oftentimes on state law, but in Illinois, for example, the agent under a power of attorney will have more authority than a guardian. In fact, if a person files a petition for guardianship seeking to have a guardian appointed in court, the defense of that could be the presentation of the power of attorney to say, Judge, I already did planning, and I don't need a guardian, and my planning under this agent was to have my wife be my agent. In Illinois, that will trump the guardianship and many other states. So I would be careful when oftentimes people will talk about, well, go get guardianship. If the person has already done their planning properly, a guardian will not be needed. Oftentimes you hear people say, well, do a trust and avoid probate. Well, guess what? If you have a properly executed power of attorney, you can avoid probate, and probate being in the guardianship or the guardianship or conservatorship in your state.
Okay.
Are there any other questions?
Yeah, actually, I have a kind of a twofold question. Someone's asking about power of attorneys if they need to be rewritten every year, and then someone else asked specifically about a state mental health power of attorney. So I guess you can answer the question about the power of attorney, but then also lead into, I guess, finding an elder law attorney, and I assume each state has their own specific laws, so that's real critical.
Yes, it's very critical, and that's why I mentioned that I'm not giving legal advice today, because we cannot do that. But let's talk first about should a power of attorney be rewritten every year. I say it should be dusted off every year, just so that you make certain that you have the person that you want to serve as your agent. I always give the example of myself 30 years ago when my wife and I got married, we did a will and a trust, and we did our powers of attorney. And we appointed people in our wills that, my goodness, that looking back 30 years ago, they were perfectly appropriate people, but oh my goodness, we wouldn't want them to have raised our children. Thankfully, we didn't have to worry about that. But I use that example to suggest that it's a good idea to dust off your estate plan once a year, once every couple of years, to make sure that it has all the provisions that you want. I mentioned the mental health powers of attorney. In Illinois, they're called the Mental Health Treatment Declaration. Those are very powerful documents for people with diagnosed mental illness. And they're very important documents for people who understand that from time to time when they go off their medication, they can cause all sorts of havoc with their families and their loved ones. By entering into one of these, what I call superpowers of attorney, a person with mental illness can agree beforehand, and it's an advance directive, to say, yes, you can admit me into the hospital in Illinois, for example, for up to 17 days. Yes, you can consent to medication even against my will, or yes, you can consent to the use of ECT against my will. The person's entering into this agreement when they're competent, and at the time they may want to terminate the power of attorney for health care. You would have this second power of attorney that would be able to get the job done. How to find an elder law attorney. Right. The National Elder Law Association is a good place to start. NALA. They will have lists of all the member attorneys. But I would really drill down a little when you're talking to the attorney to make certain it's okay to ask an attorney, how much does it cost? What kind of experience do you have? How many guardianships, or whatever you're asking them to do? Ask her or ask him what their experience is. As a consumer, you have a right to do that, and you have to trust the lawyer that you eventually select.
Okay. We have a lot of questions coming in. I'm trying to sort through them. One person did ask, which I don't know if you mentioned this or not, does a person with a power of attorney have access to someone's medical records?
Absolutely.
Okay, so they do.
An agent under a power of attorney would have as much authority as the principal gives them. And certainly one of the things that would generally be in a power of attorney for health care would be the right to access medical records. Yes, absolutely.
Okay, and someone has asked, what is self-neglect?
Self-neglect is really a big issue in the elder abuse area now. I actually have a case that we were working on the other day, and the woman was living in her house alone with no running water, no electricity. Many of the windows were broken out, and she had been reported to the Elder Abuse Agency, which I represent. When the elder abuse investigator went in and saw the papers stacked up and a number of cats running in the house, the woman was perfectly content, was safe, and said, you know, where I came from, when I grew up, we didn't have windows. We didn't have running water. We didn't have electricity, so I'm perfectly content. So the question there is, you know, that's okay when it's 98 degrees in July in Chicago. Is that the same okay when it's 10 below zero? Probably not. So the difference is when a person is what we would consider as self-neglecting themselves, not taking care of themselves, not cleaning themselves like many people, not being able to toilet themselves, not having running water. When does that ability to say, wait a minute, this is not a good decision, and we should step in and try to intervene in their life. So that line is not always as clear in these self-neglect cases. It's a big issue in the field now.
Is it? Kind of a similar issue. Someone has asked, it sounds like they have a situation where mother and father are still living together in the home, but the father is a little bit less, I guess, his mental faculties are going, so he's causing some issues for the mother because he's always been the dominant person in the relationship, and so he's not asking for help or accepting help that could help both of them. So I guess what do you do kind of when it's affecting another person in the household as well?
Those are so difficult cases, and particularly for that generation where the man was the king of the castle, and oftentimes, and I'm not, agreeing to this at all, but oftentimes in the 80 and 90-year-olds, women were so-called subservient, and the husband was always right. And we see that being played now where, the husband, again, I'm just using this as an example, not to sound sexist, but the husband may not be thinking clearly and is actually abusing his wife or not allowing people to come in their home or making her do things that aren't right or not allowing her to go out or we often encounter these very difficult circumstances, and the wife feels like if she goes to get help, she's betraying the man that she's lived with and been married with and has loved for the last 60 or 70 years. It's very complicated, and that's why it's helpful to get professionals who are familiar with working with this. When do you go for guardianship? Is guardianship appropriate? Is that going to fracture the family more? And it gets more confused when father and mother, this may be the second or third marriage, and you have stepchildren, and you have alliances, and you have people protecting each other or not wanting to protect each other, and money's involved or money's not involved. It depends on the facts of each case. And getting good professionals to assist you is very, very important. MPDA, of course, has advocated strongly to get skilled care providers into homes who are licensed, bonded, and insured. And they've advocated strongly, again, in Illinois, where they got licensing passed to ensure that these, that the professionals can be assisting in these very difficult cases.
Okay. One other, I think probably have time for one more question. We have someone who, and I think it's something you kind of talked about initially, but I'm not sure if you went into it in depth. Basically, what if your parent does live out of state? You live in a different state. How does that affect the whole power of attorney agent issue?
It's possible to serve as an agent even when you're out of state. In the old days, before national banking, it was more difficult, but today, because there are so many national banks, you can do the banking. You can do banking by online, and certainly so agency to do their books and their pay their bills and everything is made much easier by all the electronics that are involved. To serve as a power of attorney for health care, it's often better to have somebody local if it's possible. If it's not possible, healthcare providers are used to talking with people through email, through fax, on the telephone, and agents can appoint somebody in the local area to help them. So care managers and licensed care managers who will provide services to be on the spot to give them information is a very, very important consideration for people who are living in other states and have jobs and children and responsibilities that do not permit them to be there every day. So lots of options, again, if you're using professional
like it.
people.
Well, Joseph, I think we're just about out of time, and I appreciate your expertise. It was a very great presentation, lots of good facts and information in a kind of a tight time frame, but you did a great job. Just to let everybody else know, as you can see on the screen, privatedutyhomecare.org is the website for the NPDA, so obviously go there if you have any questions or want to find more information about home care. And we have recorded this event, so we will be sending it out to everyone who is registered for the call. And again, you can find the resources on the slides. You can refer to the information. You'll have the audio and the video portion of it. I just want to thank you again for taking time out tonight for this NPDA caregiver event. And we will be offering more in the future. We have one coming up in November talking about how to develop a care plan or creating a care plan for your parents. And we look forward to providing those for you in the future. As we close out, you'll see a survey pop up on your screen. We appreciate your input. And again, thank you for coming. Thanks.
Thank you. Please stand by.